For those of you who weren't here this morning, I'm John Guzet. I'm the Director of Legal Studies at the John Locke Foundation, and I've got the pleasure of introducing our third panel, who will discuss how we can go about building a better criminal code in North Carolina. Starting from my far right, I'll introduce the panelists in order. The first is Jessica Smith. Jessie's the W.R. Keenan Jr. Distinguished Professor of Public Law at UNC's School of Government. She's also, as you've already heard, universally recognized as the go-to expert when it comes to North Carolina's criminal law. And in fact, all across the state, judges, prosecutors, defense lawyers, law enforcement agents, they all rely on her. Jesse, hold it up. Show them the book. Guidebook to the Elements of North Carolina Crimes. It's over 1,000 pages now, including the supplement. And as you heard, they need it because the criminal statutes are so complicated. But she doesn't just bring that expertise to us today. I mentioned earlier that Jim Copeland's report on overcriminalization in North Carolina was what brought these issues to the attention of many of us here in the state. But it was Jessie's white paper, and I think some people have also referred to that. In 2017, she published a white paper explaining, laying out a comprehensive plan for recodifying North Carolina's criminal law, and that's what convinced a lot of us that these problems really could be solved. I'm hoping there'll be some more copies of it. All the ones we brought with us were taken early, but I hope there'll be some more out there before we leave. The next panelist is Marcia Morey. Marcia represents me and all the other residents of District 30 at the North Carolina on the North Carolina House of Representatives. But she doesn't just bring legislative experience to this panel. Prior to joining the General Assembly in 2017, Marcia served for 11 years on the bench of the District Court in Durham County, and for the last 6 of those years, she served as Chief District Court Judge. Given the breadth of Marcia's experience, it would have been great to have her on every one of our panels today, but we're lucky to have her on this one. And last but not least, Rose Williams is the Associate Executive Director of Public and Government Affairs for the North Carolina League of Municipalities. We're particularly lucky to have Rose here because, as many panelists have already mentioned, reforming North Carolina's criminal law is probably going to involve rethinking the way the General Assembly delegates power to local authorities. In fact, this issue already came up this session in the debate over Senate Bill 584, and when it did, Rose did a great job of presenting the League's concerns and interests to the legislators and other interested parties, and I'm sure she'll do the same for us today. Jesse, will you start the discussion by telling us a little bit about how you think we can improve the criminal code here?
It involves a lot of people who do bad things, people who are charged with and have committed murder and rape, kidnapping, and home invasions. Those aren't the people that, when I think about overcriminalization, that I'm thinking about. The people that I'm thinking about in the system are the majority of people. And they're in the massive misdemeanor system that makes up our criminal justice system. Those misdemeanor charges are by far the most charges, and they're the most convictions. About 3/4 of the sentences handed down in North Carolina are for misdemeanor offenses. Of the misdemeanor convictions, we have 25% of them are for Class 3 misdemeanors, the lowest possible level of crime. And so those people aren't going to prison. They're not adding to our prison populations, but they're getting criminal charges and they're getting criminal convictions. And let's not make a mistake about what that means for them and the prosperity of our communities throughout North Carolina. I mentioned this morning in a meeting that when I was on the Chief Justice's Commission for the Administration of Law and Justice, Andrew Murray, who's one of our conservative prosecutors from Charlotte, he's now a U.S. attorney, said in those commission proceedings that a misdemeanor conviction can often be a lifetime sentence to a life that never gets above the poverty level because of the consequences for employment, public housing at all, military service, college financial aid, and all of those other consequences. So when my comments are largely focused on that massive misdemeanor system that we have. And in that respect, I have 5 recommendations for what we should do about this issue. Here's the first one. We should look at everything that we've made criminal and everything that we're thinking of making criminal. And we should ask 3 core questions. The first core question is the conduct morally culpable? Is it morally culpable such that it deserves the extreme sanction of the criminal law? So you decide. We talked about ordinances. City of Rocky Mount, Code of Ordinances, 19-64. Each occupant of a business which fronts a paved sidewalk shall clear the snow which may accumulate on the sidewalk in front of the business within 12 hours of accumulation. The failure to do so is a misdemeanor. Is it morally culpable conduct that deserves the sanction of the criminal law? No one's going to make the argument here. Mike mentioned the silly strings. That's an ordinance. It's the City of Mount Airy. Code of Ordinances 10-14. It's a misdemeanor for any person to sell silly strings within the corporate limits. That's not a code word for drugs. That's the stuff that comes out of the can that the kids use on each other. He also mentioned Curie Beach, where it's a crime to twice wear a thong bathing suit. I don't want to hear any comments. I know some of you might think that should be a crime in certain circumstances, but there's a lot of this stuff. Screeching tires, barking dog, leash law violations, all of these things are made criminal in North Carolina through ordinance crimes. And they're funny until we remember that we're flipping on the switch of the criminal justice system. We're using taxpayer money in this incredibly expensive system, and we're giving these people, at a minimum, arrest records and sometimes conviction records. And there's another kind of sobering aspect of that, and that is the criminalization of poverty and homelessness in North Carolina. And we do this. We do it all the time. We do it when we criminalize, as many towns and counties do, through ordinance, begging. Soliciting alms is the single most commonly charged ordinance crime in North Carolina. We do it when we criminalize sleeping in public parks. We do it when we criminalize public urination. Yeah, there's some people who drank too much at the bar and go outside and do it, but a lot of those crimes, the prosecutors and law enforcement tell me, relate to people who are in fact homeless. Now, many people would argue that being poor and homeless isn't itself morally culpable behavior. The mom who goes bankrupt because of medical bills trying to save her baby child with a rare blood disorder and is homeless and is begging on the street for money to provide food for her surviving child. That's a crime. Is that morally culpable behavior that we want to use the criminal justice system to regulate? These are questions that we should be asking. It's not going to be a long discussion or even any discussion about the crimes that I started with, the murders and the rapes and the home invasions and the assaults. But these are serious questions that we need to ask as to that other type of conduct. The next question that we should ask is the justice system even effective at dealing with the issue? So let's take begging. Mom Mary, who's begging to get money to feed her child. She gets charged with that crime. She goes into the justice system. She did it, so she's going to get convicted. Now, it's a Class 3 misdemeanor, and most misdemeanor defendants, and certainly almost all Class 3 misdemeanor defendants, are going to come right back out of the system. What is she going to do when she comes out of the system? What did she go in for? Is her situation improved by involvement of the justice system? In fact, it's worse, because now she has a criminal record. So any hope that the local church had to maybe get her and her child into public housing, get her a job, other services, she's now got a criminal record that's going to create a barrier. And there's more. She was poor when she went in, but now she has fines and fees that she has to pay. So she's actually poorer. She's in a worse situation. And we see that sort of cycling of people through the system, not just with poverty and homelessness, we see it with mental illness. When one of Eddie Caldwell's colleagues get called out to deal with a disturbance on the street that involves someone who has an untreated mental illness. And they go into the system and they come right back out, and we did nothing to treat them in between, and they're going to engage in the same behavior. Same thing with substance use. That's why I say that's the second question. So the first question is it morally culpable? The second question, is the criminal justice system effective? And the third question is, even if you think that the criminal justice system is a wee bit effective, we should, as public servants, as taxpayers, we should be asking, is the criminal justice system the most efficient way of dealing with the system? The criminal justice system is really, really expensive. First, we got the cost of the court system. The AOC releases data on approximate costs that it takes to prosecute crimes. And $404 for disposition of a Class A1 misdemeanor, $233 for a Class 1 misdemeanor. An infraction, a non-criminal infraction, anyone want to guess how much that costs by comparison? Any guesses? $44. A non-criminal infraction costs $44. But it's not just the court system costs that are at issue. It's not just the court system. Those are a fraction of the costs that are at issue. A lot of these people that are charged with low-level offenses are going to end up in jail pre-trial because of all kinds of issues within our pre-trial system. I know that so. I've been looking at jail logs across North Carolina for about the last year and a half. And we routinely see people charged with the lowest level misdemeanor offenses spending time in jail. That's a cost that's not accounted for in that money for processing the case because that's a cost that the county pays at the jail level. Not just the daily jail cost, which some of our jails that can cost almost $100 a day. It's the medical care, the substance use, the mental health treatment that all has to be delivered in that incredibly expensive setting. And there's also all these other negative consequences that we're now learning when we incarcerate pretrial people charged with very low-level offenses, including the likelihood that they're going to commit more crime greater likelihood that they'll commit crime when they're out, because they lost their jobs and they may have lost their home, and it's this whole cycle of criminality that starts. So those are some additional costs, but there's more. When we're doing all this massive policing of so much behavior, we're diverting law enforcement attention from the serious stuff that communities really care about to all this minor stuff, because the law enforcement must respond when someone calls about the screeching tires and the barking dog and the noise violation and whatever else it is. There's another thing for law enforcement, and that is with all of those interactions between law enforcement and the citizens, there's an opportunity for escalation. An escalation that's dangerous for the officer and dangerous for the individual. You've heard of the Eric Garner case out of New York, right? The Eric Garner case, he ended up dead. Does anybody remember what the police initially approached Eric Garner about? Selling loose cigarettes. They approached him about selling loose cigarettes and he ended up dead. That's a huge cost, loss of life. But if you aren't thinking about the cost that those kind of spiraling negative interactions have for the trust between law enforcement and the community, you need to think about that because it's incredibly damaging. And when law enforcement are repeatedly called out to deal with problems that haven't been addressed in the community, substance use, mental illness, poverty, and homelessness, we're also putting our officers in danger, particularly in responding to people who are mentally ill. So those are costs that we need to consider as well. And while we're considering all the costs and deciding if the criminal justice system is the most effective way to deal with this low-level behavior, let's take into account the economic impact on the prosperity for North Carolina of saddling hundreds of thousands and millions of people with criminal records that are a barrier to employment, education, military service, all of the things that we know people need to be productive members of society. Because in the end, what we really want is public safety and economic prosperity. So those issues should go into our analysis. The three questions: is it morally culpable? Can the system even do anything about it? And even if the system can do a wee bit about it, is it the most efficient way to address the issue? That's the first thing we should do. The second thing we should do is we should regularly review our laws, as has been suggested, to repeal, modify things that are outdated or unconstitutional. Here's a statute in North Carolina. General Statute 14184. If any man and woman not being married to each other shall lewdly and lasciviously associate, bed, and cohabitate together, it's a class 2 misdemeanor. Having sex out of wedlock is a crime that's on the books in North Carolina. Now, once, that doesn't count. You gotta do it habitually. We actually have a case on this. You can look it up from 1945. Do we want to be criminalizing that behavior? Well, even if we did, too bad, because it's unconstitutional. In Lawrence versus Texas, the United States Supreme Court said we can't criminalize private consensual behavior between adults, not for money. So that's an example of something that probably is out of sync with society, but it also happens to be unconstitutional. Here's another one. It's on the books. It's not in Chapter 14, because all the crimes aren't in Chapter 14. You already heard about that. Misdemeanors are in 142 chapters. If any person owning or having any bitch shall knowingly permit her to run at large during the erotic stage of copulation, he shall be guilty of a class 3 misdemeanor. Outdated, in sync with what we want to criminalize? I don't know. We should at least be reviewing our statutes to decide, do we really want to keep these things on the books? Now, maybe the General Statutes Commission can do this. Maybe we need a more specialized review. I'm not a tax lawyer, but we've got something called the Revenue Laws Study Committee. I think we've got some tax lawyers in here, and I understand, correct me if I'm wrong, what they do is they look at the revenue laws every year pretty much and or on a regular basis and make sure, does anything need clarification or technical amendment? Maybe something like that is feasible for criminal law. So first, ask those 3 questions. Second, regular review. Let's repeal the things that are outdated and unconstitutional. And while we're at it, number 3, let's get rid of the duplication. Let's get rid of the duplication. People have talked about larceny a little bit, but for those of you that are in the criminal law, here's what you need to understand about that. We have a common law crime of larceny, right? And it's not just 1 or 2 other larceny crimes we have. Here's the list. We have the general crime of larceny. Larceny of dairy crates, larceny of motor fuel, larceny from a construction site, larceny of secret or technical processes, larceny of public records, larceny of wills, larceny of ungathered crops, larceny of ginseng, larceny of pine needles, you heard that, larceny of portable toilets, heard that one, larceny of political signs. I got an idea. Let's have 1 crime. You can't steal other people's stuff. Doing this, we're eliminating all this unnecessary repetition and complexity. In district court, we initiate about 1.3 million cases a year. In district court, 1.3 million cases. We only have 10 million citizens in all of North Carolina. That's a massive criminal justice system, so any complexity, duplication is costly, and we should take a look at that. Fourth, we ask the core questions, we get rid of the outdated stuff, we eliminate the duplication, and the next thing we do is let's put it all in one place. We've heard this suggestion made already today, and Chief Justice Martin basically suggested that no one can answer the question of how many things are criminal today in North Carolina. And a basic principle of law is that it should be knowable. We heard about the crimes are scattered throughout the statutes. They're in administrative regulations. They're in ordinances. And under our system of law, ignorance of the law is no excuse. But is it really fair that we apply that principle and there isn't a single person here today who can tell us everything that's been made criminal in North Carolina? So at a minimum, there should be one place where everyone can go and see everything that's been made criminal in North Carolina. And finally, suggestion number 5 is once we have everything in the same place, one thing is going to become painfully obvious. We have massive overlap. We have instances where the exact same conduct can be charged under 2, 3, 4, 5 statutes and maybe a couple ordinances as well. If the appropriate offense was graded, had the appropriate punishment, we wouldn't need to have all of that overlap. And when you have all that overlap, each of those crimes has different elements, and each element has different definitions. And it's just, again, complexity adds costs in a really big system. And there's another thing that happens, and it came up in the panel right before lunch, and that is when the prosecutor has the option to charge you with 5 offenses for one act, it gives the prosecutor a really powerful weapon to coerce a plea. Perhaps that's one of the reasons why we see the statistic about 98%. It's not the only reason. It's a contributing factor for why so many people would plead guilty. We have a solution to this. We apply it spottily in the criminal law, which is to add this initial language to a statute that basically says, unless another statute provides a greater punishment, which makes it clear you can't have multiple overlapping convictions. One act, one conviction. That would go a long way towards eliminating complexity, but also eliminating arbitrary enforcement where, the Durham DA does it one way, but the DA in Johnston County might do it another way, and removes that coercive element of having an individual face multiple charges. Now, nothing that I just said is terribly controversial. And I say that because back in March of this year, I had North Carolina's first criminal justice summit. We had 240 people from across North Carolina come to hear about 4 issues. One of those issues was over-criminalization. Oh, and by the way, I'm going to have a trademark lawsuit against Locke Foundation for the title of this event because you're trading on that name. See how I did that? Not a criminal charge. I enforced it through the civil system. Had a beef with John, enforced it through the civil system. But at that summit, when we took up the issue of over-criminalization, we had 4 experts on the panel, 2 national experts, 2 state experts across the ideological spectrum. We had Vikrant Reddy from the Charles Koch Foundation at the national level, and Nathan Pasno from the North Carolina Association of Criminal Defense Lawyers. Not exactly likely bedfellows on an issue. At the state level, we had Tara Callahan from the Conservatives for Criminal Justice Reform, and we had Mary Pollard, who's here from Prisoner Legal Services and then was the president of the North Carolina Advocates for Justice. And again, there were 240 people there. There were legislators, there were Rs, there were Ds, there were prosecutors, there were defenders, there were law enforcement people, there were judges from every single level of the court system. And after the panel discussion, when folks heard from those folks, we did live anonymous polling through the little clickers, you know what I'm talking about, little clickers you sometimes use at conferences. And the first question that we asked people was, agree or disagree with this statement? 240 people, diverse audience. Over-criminalization is an important issue in North Carolina and we need to work on it. 89% of people agreed with that statement. We then asked them, well, what do you think about 3 suggestions that diverse panel all agreed on as viable solutions for North Carolina? The first was a commission-supported legislative purging effort, that sort of review that we've been talking about. And the people in the audience voted, and 93% supported that issue, that recommendation. Also, the panelists, the 4 panelists came up with these recommendations. The second recommendation was repeal the provisions that allow the delegation of authorities to administrative boards and bodies and local governments to create crimes by ordinances, and 76% supported that. And finally, the third suggestion that those panelists came up with is for bills proposing more new crimes, give legislators more information about, do we need the law? Does it already overlap with something we have? 94% approved of that suggestion. So it seems to me that there's broad consensus that it's a problem, and there's broad consensus as to some of the solutions. And I look forward to hearing what my panelists have to say and getting your questions.
Marcia?
Anyone else want to go after her? I feel like I just had 10 cups of coffee. Wow. Thanks. It's great to be here. And I think I'm going to take a whole different approach, not from an academic viewpoint at all, since I'm not an academician by any means, but just my personal experience in the criminal justice system, because that's where I take whatever I am now trying to do in the General Assembly forward. So it was 24 years in criminal justice, and starting out in Durham as an assistant DA, and hired because I had never been in a courtroom. And where did they put me? They put me in a juvenile courtroom, because you can't screw up in a juvenile courtroom, nobody's watching. But that's where I really got my passion of what is our system? What are we doing with children in this state? And I think pendulums swing, and they swing in how we approach criminal justice. And they certainly did in juvenile justice. Because when I started out in the late 1980s, 90s, the way we got kids help, we brought them into the system. We had probably half of our kids petition undisciplined. They hadn't committed, quote, a criminal juvenile offense. They were undisciplined. They were out of the parents' control. We had training schools being built. We had 1,500 kids in 1990 in our training schools. 1,500. More in detention centers waiting to come in. And they were there for trespass. They were there for truancy. They were there for minor offenses or running away. And we were bleeding money into this system, not to mention our adult system, as in the mid-90s, that's when, especially crack cocaine and the epidemics of horrible drug trafficking were coming up, and violent crime. But I watched the system, and I looked out, and who was in our courtroom in Durham? 95% of the kids I saw were African American or brown. They were minority kids. And I would see a case come in, and it would be 5 white kids selling Ritalin in a middle school. They were diverted to counseling. But a black kid with a blunt in his pocket was brought in on an adjudication that we brought before the judge. So these inequities, in my mind, and what we saw, just kept growing and growing. And then we had one case of a 13-year-old who murdered a 90-year-old woman in Durham with an axe, a next-door neighbor, and he wanted her car. And so he beat her to death. And this one case got so much attention, the General Assembly, within months, introduced a law: any 13-year-old who is charged with murder must be transferred to the adult system, because before it was the 13-year-old, the minimum age was 14. So you watch one case change things for the entire state. And after doing that work and speaking out more and more about the juvenile justice system and the inequities, I was asked to go work with Governor Hunt. And what was our charge? What we're doing today with the adult system: rewrite the entire juvenile code of North Carolina. And we spent 2 years going around the state, working with, it was the Governor's Commission on Juvenile Crime and Justice. But I think he set a model of bipartisan legislative leadership, of justice, of defense attorneys, of child advocates, of prosecutors, of family members, of people who serve juveniles. It was a commission of 64. We traveled throughout the state to 8 cities. We went into training schools. And the whole commission, it was Governor Hunt's last year running in his 4th term, and his campaign literature said, we've got to stop these punks and thugs. And after the end of this and going into a courtroom and sitting there and into training schools and seeing the real stories, this commission didn't go out to change and get these punks and thugs. It became a very balanced. Our juvenile crime rate dropped 38%. You know how many kids we have in our training schools now, which we call youth development centers? Fewer than 200. But it took everyone from all walks of life, all political persuasions, all aspects of how you handle juveniles to make it work and not become political. And I think we're all here because we see the need that Jesse and everyone else has so eloquently described, that I totally agree with. Then my perspective after working on the juvenile court reform was sitting on the bench. 18 years, looking out at criminal court, looking out at first appearances, the racial inequities, the socioeconomic. To watch someone who couldn't get into the door of a courtroom because we had 300 cases on and we had 180 seats, and they would be arrested for failing to come to court. They were in the hallway. they couldn't get through the doors of the courtroom since we were overcrowded. And then they get picked up on a traffic stop and there's a failure to appear on another traffic case and they're taken down to jail and they don't get an unsecured bond, they get a secured bond. And when they come into court, they have a FTA, failure to appear fee, they have a late fee, and if they can't pay it, we add another $20 partial payment fee for their future costs, which if they can't pay, they will go back to jail. The revolving cycle of injustice. And so to watch that affect people, and I'm like Jesse, I wasn't in Superior Court, I was dealing with misdemeanors mostly in criminal court. To see that play out with hundreds and hundreds of people every week in one district court in Durham was amazing. So with what I experienced there, raise the age, which we have been fighting for 20 years, and I have to shout out Brandy Bynum is here, who is with NC Child, who is one of the leaders of advocates to help get raise the age through with our elected officials, was marvelous. But I mean, that's why I wanted to go to the General Assembly. It was coming up. We had to push this across the finish line. And it was bipartisan, you know, and it will become effective December 1st. That took almost 20 years. What will something like this take? I think the need is there. I think everything that has been explained of why we need to do it, we need a constant periodic review of cleaning up our criminal statutes for all the reasons that we have said. But I would say just as important, we can't just look back and clean the house. We have to look forward. We have huge pressing issues, especially with criminal procedures, especially with bail and pretrial release. Should it be based on someone's pocketbook? Should it be based much more on fairness and appearing in court? We have a Supreme Court decision, juvenile life without parole is unconstitutional. Well, the General Assembly has not acted to make sure we are in conformity with what the Supreme Court said, and we're still litigating one by one juvenile life without parole cases. I mean, we have to stay up to date, you know, and we have to prioritize where we need to be going. So it's a huge endeavor. I wish we had a standing committee solely on criminal justice issues and reform. We used to have 4 judiciary committees. This year we had 1 judiciary committee handling civil and criminal, you know, when there was so much more to be doing and working on. And, you know, I'm committed to it. I know our other legislatures are very much committed to it. It is not a partisan issue. It's really fairness and justice in this state. So, thank you.
All yours, Rose.
Thank you, John, very much. I am appreciative of everything that you've said, and the other panelists here. Part of my experience in my career, you might call it a lack of direction, but I've had a chance to, when I was clerking for a justice of the Supreme Court, to know and learn for the first time that, oh my gosh, some people have appellate lawyers, and they win, and they don't know it wasn't because they're a lawyer. You're shocked at what gets presented even, but the court did the right thing, and justice was served despite what briefs were filed. And then I went to practice law, and in a smaller town in East North Carolina, with some very fine men, and great, because it was all male law practice, great people to learn from. And I learned a lot, but I saw a lot as well. And then I had the privilege to go on the trial bench in the district court, Wayne and Oregon counties, and saw more. And that's where Judge Moore, and I say it all the time, I won't embarrass you, but he's such a hero to me. Since I was the first female they'd ever had, they put me in juvenile court once or twice a week in all 3 counties, because I'm a woman, I'd like to handle that. Well, the first thing you learn is when I pick up a file one day, how can this child have a file that started, you know, the day he was born? I don't understand. And that's because this child went into the system the day he was born at the abuse and neglect level, and later we might have him in a criminal case in the juvenile system. And so I've seen the things we refer to here. You see legislators sometimes responding to a need, a tragedy that happened in the state. I've seen it in the decade that I've been lobbying. And they want to do something. They genuinely do, and they want to make a difference, and they want to tell people at home, we're going to stop this. This terrible thing that happened, whether it be an explosion in the Outer Banks or whatever happened, a child that couldn't be found, we're going to change the law and make a difference. And although it really couldn't have made a difference, and even though it really wasn't necessary, there already was something on the books. I was with the governor one time, he was about to do a bill signing. And the question right before his needed some talking points, and the person had to say honestly to him, actually, that would make a change. You know, it was really popular, and everybody, and that is the truth, and that's what happens. On the local level, we represent in the North Carolina municipalities 552 cities and towns in the state of North Carolina. 552 cities and towns, and how many thousand elected officials and appointed officials in those towns who similarly want to do the right thing and try to help their constituents. And we're all different in North Carolina. We have 200 cities that have less than 1,000 people, and many more that have less than 500 people, and they operate without a manager. These elected officials are doing their best to keep the water system going, keep the roads going, collect the payments that have to be made, as well as they work their own job or do whatever they do. And it's a great service. We have 6 towns that have more than 200,000 people. And of course, that's where the key part of our population in North Carolina is and where it's going to continue to grow. Folks who are moving into our state are going to the cities. They're not going to farms. And so this is going to continue to change. We're urban, rural. We're suburban. We are resort towns, convention cities, college towns. And everyone has different approaches and different needs. And I spoke this morning at breakfast about a beach town that might have an ordinance about if you're going to surf, you better have it tethered to your foot or your ankle. And that's because somebody got hurt. Someone was seriously hurt when that surfboard took off and went. And to their credit, that's probably posted on a board when you go into the beach. But that's where that came from. And the mountain town might have something different. The convention city might have other needs as well. So I would think that our cities and towns want is something, whatever, that's moderate and reasonable, and we're very grateful that a close look is being taken. I think certainly one to preserve life, health, and public safety prohibitions that promote the protection of life and health and public safety. I think when the Boston Marathon bombing happened, that city shut down. There are curfews, and hurricanes happen here. There are curfews that come into place. And yes, there may be some that might be, it sounds silly and ridiculous. It's Philly Street, I don't know where that came from. Eddie Caldwell mentioned the pine straw and where that came from. And I can see that. We just want to make sure that it makes sense. And then if it's going to be criminally enforced, and they all are not, a very small percentage are enforced criminally. And that's because I'd like to assert that a lot of it's because they're not, maybe they're not needed. They need some of them, but when they are needed, it's a deterrent. And that's what's necessary, for the use as a deterrent. Not so much wanting to prosecute somebody criminally, but it might not make a difference to send that civil notice to someone that they can just pay that as a cost of business or ignore it. But maybe if there is that chance of even a small criminal prosecution, I would not want to have a class 3 misdemeanor on my record either, and I know a lot of people wouldn't. And so that might make you wake up and look at that, but otherwise you might not. People don't know the law, and that is true. I remember in district court one day, a lawyer walked in Kinston, and he had the green statute book with him, and all the other lawyers went, because he was carrying the book of law. They know, I think they deal most every day with the law, and they know which ones they're dealing with. But query if our public even knows what's in the general statutes. But they should, and it's like kicking the dog. You know the difference between kicking the dog and stumbling over the dog. As I think it was Justice Martin's presentation that pointed that out. But if there is going to be a criminal prosecution, of course, it has to come from a sworn law enforcement officer. And then it is taken to the district attorney. And in North Carolina, unlike in some other states, in North Carolina, the district attorney is solely in charge of those prosecutions. And solely in charge of what is taken to court, when it's taken to court, and how it's taken to court. And then if that happens and it does become before the judge, then it does become before the judge on a beyond a reasonable doubt standard, our most extreme or strong standard of review, unlike the civil standard, which is much less. It has to find beyond a reasonable doubt that that is the case. Do plea bargains take place and maybe an ordinance is used? When I read the screeching of tires, I just couldn't help but remember when I was practicing law. We used that a lot, and the DA would take that at the time. They would throw in a screeching of tires instead of whatever traffic infraction or traffic charge you had, because there's no insurance points. And people were happy to take that and pay that fine and go rather than pay the insurance company an increased amount for 3 years. So those things happen. We're very grateful, and I'd be remiss if I didn't mention the statute's been on the screen earlier to Representative Maury and Representative Riddell and Senator Wells, who was here earlier today, and he's still here. And the work that they did to take a bill this session that had originally said, okay, city ordinances, they're all gone. Boom. No more can you enforce them criminally in any way. And I think everyone came to the table and realized that throwing the baby out with the bathwater is not the way to go. We need to take a slow approach and look at this. North Carolina has done it in the past, it's been mentioned. I mean, just think, we don't have municipal courts like some states have. We have a consolidated court system, and just think some states, I don't think, have that. We've done a lot through the years. There may be more to go, but just think how what it could be if we hadn't done those things. And make sure I covered everything else. But we're going to have a study in North Carolina, and the General Statutes Commission has already had a meeting to begin trying to think about how they would look at it. And we just hope that there would just be a moderate approach in considering life and health and public safety, and if we're going to have a consolidated system or a set of statutes, or go back to the Napoleonic Code, or whatever we're going to do, just have that included. I think that's all I would want to say.
Well, thank you, Rose. Let's hear it for our panelists. I'll start taking questions now, but can I just ask if you identify yourself and who you're with or why you're here before you ask your question? Anyone? Yes, Jay.
Jay Schweiker, Cato Institute. I want to pick up just right where you left off about the discussion of sometimes you need these as deterrents even if you're not really intending to criminally prosecute. I guess I sort of understand that at a high level of generality, but it also seems like that can easily become a fully general answer to wanting the criminal code available to address any and all means of social problems, whereas I guess it seems like it's kind of question begging, because if you think it's appropriate for it to be a deterrent, surely then it must, as a matter of just basic justice, be something that would in principle be appropriate to criminally prosecute itself if necessary. And so I guess my question, maybe to kind of throw this into sharper relief, is do you think that there are any social problems, anything maybe even there should be some legal consequences for it, but which cannot be, to go back to some of Jesse's point, like, are there any social problems that actually just simply are beyond the effective reach of the criminal justice system?
Sure. I mean, I think if it really is homelessness and you've got that person there, we can't, I guess to a certain extent the jail can be home, and I certainly had people like that, and I'm sure you did too, who would deliberately break a window to try to get in jail overnight for a cold night, for a one night sleep in the jail. But there, of course it can't. Maybe can a court solve all social ills? No. Absolutely not. So if it's something like that, that is not going to cure homelessness. I think it's just the system trying to do what it can with what's been put before it. I think it can cure it. No. If that.
Jim?
Another follow-up to Rose on, there's no question that municipalities are going to have some reason to be able to develop ordinances. What is the harm, though, in saying that anything that's going to be criminal, you've got to report to the legislature has to have the opportunity to act on it. Given that municipalities are creatures of the state government, why shouldn't the elected statewide legislators have a crack at looking at these things before they become criminal?
Well, so let me think if I understand your question. The legislature passes laws, makes crimes, they go into the general statutes, and there are ordinances that can be enforced criminally. That power was given to cities and towns in Chapter 160A and counties through 153A to do that. And so I guess some people might say those people in local government are closer to the people and might know what's needed in that area. And they're passing those, but they were using what you're, I think, proposing is instead of having the authority on the front end, okay, 168 says cities can pass ordinances. Maybe you're saying on the back end, every city should go to the General Assembly before they pass an ordinance that might be enforced criminally.
Well, before it's criminally enforceable.
Right.
Which doesn't mean that you couldn't pass any ordinances you like, but before it's criminally enforceable, because ultimately the entire incarceration process of the state's going to be brought to bear. And individuals are going to potentially lose their liberty. So why shouldn't this go back in front of the elected state legislators for review? I mean, you can structure it various ways. You could say, well, the state legislature has 6 months to act, and if they don't, then it becomes a criminal review. Just so that there's a notice given, so that if the silly string thing is created in Sarah's hometown, there in Mount Airy, then the legislators can take a look at it and decide if it's necessary.
I think, just from their point of view, from the legislature's point of view, they're gonna get inundated, and maybe they can handle that. Maybe another way to handle it is the study that's going on and handling it that way. So there are different ways to handle it, and you can do it piecemeal, and that was something we discussed in the original part of this. And as Senator Wells said, you can go to the General Assembly for any of these that you want. It's just that it's a whole lot. So I think just housekeeping and trying to keep that up. I hope that there aren't too many silly strings out there. I have to say, out of all these hundreds and all these thousands, just me. So have to admit.
I'm Rich Leonard. I'm the Dean at Campbell Law School. And Jesse, I was listening to you talk about tax lawyers and the process they have for reviewing the tax statutes. I've been heavily involved in the Bar Association. That's not unique to the tax lawyers, family lawyers, the property lawyers, the wills and trust lawyers routinely go through those statutes and update them, revise them, and really in those areas we have pretty good codes that are all in one chapter that deal with that subject matter across most of the North Carolina law. This seems to be the aberration. And the question is, sort of, why has that process not worked? And as I sit here and think about it, it actually might not be in the interest of the criminal defense bar to make it do something. It might be nice to have a lot of crimes. To have the overlapping ambiguity might be a source of business. There might not just be the same incentive to regularize this that there is in the other area.
Well, it seems like the same incentive in every branch of the law. More complexity. more
Hopefully
work
our
for lawyers.
policymakers will think about what's best for North Carolinians, right? That's what we hope.
But there doesn't seem to have been the same sort of effort among the volunteer bar to take this on as a project that I've ever noticed.
The criminal defense bar, Bentonville, North Carolina Prisoner Legal Services, criminal defense bar is not looking for more crimes. In case anyone was wondering. The fewer number of things they can be charged with, the happier we will be.
Yes.
Joe John, North Carolina House. Several speakers have suggested that there ought to be a review or recodification of the criminal code for the purposes, one, of collecting it all in one place, and two, for clearing out the unnecessary, no longer necessary, duplicative, and so forth. All that authority seems to be clearly within the purview of the function of the General Assembly. The issue is with the conduct criminalized through local ordinances or through the administrative code. How does the General Assembly, or for where does the General Assembly, if at all, get the authority to address those two components of criminal conduct?
Well, the delegation is by statute. The delegation is by statute. In the case of the ordinances, the statute basically says unless the local government provides otherwise, violation of a statute is a class 3 violation of an ordinance is a class 3 misdemeanor.
You have the power, Representative. You have it.
I guess my question is, if we have, how do we get the power to do this recodification and cleaning process? If the ordinances and the administrative laws are already established.
We would heal them.
I mean, the statute could simply say that a violation of an ordinance is a non-criminal infraction.
We'd have to pass
Yeah,
a new law.
and now I understand you've gotten a different suggestion as to how that would happen, that you have a, request to take to take a look at that, and I'm sure there are different mechanisms to do that, but since it was the General Assembly that delegated the authority, it's the General Assembly that can undelegate the authority.
And you could do it in a swoop, but we'd love not to do
Yes.
Chris Hansford, Cato Institute. So we've gotten, one of the reasons that we love all the panels today is that there is a broad spectrum of opinion and experiences when it comes to dealing with these issues. When you look at the criminal law crisis that I would characterize here in North Carolina, how urgently, because some folks are talking about long-term studies, some folks are talking about blanket, or we've seen the introduction of blanket solutions, right? What is the level in each of your minds of the urgency of this problem?
I think it's very urgent. I think the leadership of John Locke and Cato coming forward, it is urgent. If you looked at the statistics, I think in specific sections are more urgent than others. I mean, I think our drug statutes, our drug crimes, we used to have treatment throughout the state, and then the state said, we're not providing treatment. So we have a unified court system. Durham used to have 3 therapeutic drug treatment courts for families that have lost their kids, for juveniles, for adults. Those had to go away unless the county stepped up and did the cost. We now have a mental health treatment court. Durham County is very generous to doing societal issues and problems helping, but does that violate the system of a unified court system? If it's available in Durham, it should be available in Moore County, it should be available. So I think these are all issues we really need to look at. Do we deprive one set of citizens something that we could give them because another set across the state can't have it? So I think substance abuse, the opioid crisis, it's all bubbling up to bring the entire codification of the criminal system to head.
I mean, I think it's the spring from which all of our other issues that we're struggling with come from. I mean, we're working on bail reform in North Carolina. And again, I said I look at jail rolls. I see people who are incarcerated pre-trial because the homeless person who failed to appear on a class 3 misdemeanor is sleeping in a public park. We're trying to fix the bail system, but that person probably didn't belong in the criminal justice system in the first instance. We have a bill about criminal record clearance. We're dealing at the back end with a problem. This problem is the front end. It is who enters the system. The same thing with the reentry issues we're dealing with, and dealing with the fines and fees. And many of those fines and fees and charges are on this really minor behavior. So it's like we can sort of fix stuff after it happens, or we can just accept the fact that we need to deal with this incredibly important front end issue that is not going to be easy. It's not going to be easy, but how do you eat an elephant? One bite at a time. It can be done. It's a large project that it can be done. And if we address who comes into the system and really own up as a society for how we're dealing with social ills, and perhaps deal with them in more efficient, more cost-effective manners, we won't have so many people coming in, and we'll have less of a crisis on the bail system, on the criminal record, on the fines and fees, on the reentry issue. So for me, it's structural.
Yes.
Chris Numa, actually. So the it took 20 years it took us to raise the age and
100. We said it in 1919.
Really? Okay. It took a long time, and this topic has actually been discussed for quite a while. So what are the roadblocks that keep us from moving forward on these issues more quickly?
I guess the General Assembly needs to take action.
That's for the next panel. Anyone else?
I've been on panel. I was on a panel at law school maybe a year or 2 years ago. Skip Scan was on that panel. He said, "It's a great idea. We can talk about this issue. It's just too big a project. We can't do it." And I think that's the piece of it. It is. It's a really big project. And it requires some resources and it requires some time. But in the end, it requires commitment, and it just needs to be a vision that's shared and so worthwhile endeavor. And I guess you all are going to get some feedback on what
Go out and spread the vision. Anyone else? Yes, sir.
I was going to ask the panelists how they would suggest that citizens involve themselves in the process of what members of bar, nor policy wonks who just for citizens plugging into the process to move along with the criminal justice reform.
I think so much as being aware. We used to have 3 newspapers covering our courts every single day. there's virtually no media coverage unless it's a capital case and a jury trial somewhere. And, you know, the issues that used to come up was covered by the media. You know, we have some districts get first appearances for misdemeanors, for felonies. The day after they're arrested, they have a first appearance, they're entitled to bond. Our laws don't allow people to have first appearances within any given time if it's a misdemeanor. So you can have rural counties, someone gets picked up for shoplifting, they can be in jail still for 30 days and like, oh, okay, time served. You know, stuff like that used to be covered when there were, you know, egregious injustices that would happen, and then that would get the attention of the lawmaker, and there would be a bill introduced, and something would happen. That I do think it takes court watchers. I think we just passed this new Victims' Rights Amendment that's going to have probably profound changes in a lot of prosecutions if the victim's not notified or is unhappy with the plea, and we'll see where that goes. But you know, we do need more attention paid on what is happening in our judiciary and people writing about it.
Anyone else? Yes.
I was always taught to stand when I speak to folks, don't stand. Ken Somerville, I'm the one medical person here. I want to hear what you think. I'm going to ask a crazy question here. Two things that I've heard from the panel today that I think are extreme problems. The first is the opioid addiction crisis, and the second is the mental health crisis. You know, we have people out on the streets now who used to be taken care of in hospitals. I'm not advocating you do that again, but I'm just wondering how we can approach this to more effectively treat both of those conditions and how we might be able to approach it in a different way, because it sounds like it's not working very well right now.
I'll just, Judge Moore, or Judge Moore already touched on this a little bit. I was a local judge as well. I was experienced in social work. It was kind of the social work system working as it really should. It's sitting around the table with each person trying to ascertain what all the problems are, what it's got to access to. Nothing was going to happen until we get that taken care of. How do we handle this and how do we handle that? So it takes a lot of resources. And for that to happen, the opioid crisis is, I don't have the answer. But that you have keyed in on it, and until people have help with these addictions and other behaviors, everything lose their children. You would think that that would be enough. I could never understand how, I used to just read the reports and how the child's deteriorating in foster care, and thinking that's really going to turn the trick. If she hears that, she's going to quit using. No, it's so powerful, and it's so strong, and it just takes so much. So I do not know the answer. I just know you've really identified an issue.
And it takes a partnership. You know, not just the justice system, it takes the Department of Health, Human Services, it takes clinics. I don't know if y'all read, we had a chief district court judge of 20 years in Greensboro whose autopsy just came out of heroin and fentanyl. Shocked everybody. 20 years sitting on the bench. And yet, how many dozens and dozens of you know, young teenagers of all ages, races, everything are dying of heroin and fentanyl as well. But everyone was absolutely shocked to hear the news of this autopsy. You know, these are all human lives. But one was such, you know, out of character, out of anyone's belief, that is the same system. We need all systems to come together to address and help people with addiction, and not just criminalize those that can't get any help.
Probably got time for another question or two. Anybody? Yes.
This is without facts. Is there a list of all misdemeanors in the statute?
Ish. The North Carolina Sentencing and Policy Commission has on their website, if you go to it, they have two lists. They have lists by statute number of all the statutory felonies and statutory misdemeanors, but it's just the statutory crimes. It doesn't include all the other ones that are made criminal through regulations, administrative force and body regulations, and through the ordinances. And I can get you that one if you're interested. That's how we know that misdemeanors are spread across 142 chapters of the General Assembly, because it's a sentencing policy by the commission that does this for us.
And we're working at collecting the list of all the others, but that's gonna take a while too. One more question, anybody? All right then, we still have a schedule. Join me in thanking our panelists.